cases have already been formally accused and bound over to state court. All defendants on the screen, you have an absolute right to remain silent. Anything you say regarding the facts of the case today can and will be used against you. To all participants, this particular proceeding is being broadcast over the internet and it's also being live streamed. That means that any member of the public can log on and watch this particular proceeding. I believe we are ready to begin at the jail. Who do we have first?
We got position 2, Judge.
All right, thank you. All right, are you Trebios Colbert?
Yes, ma'am.
All right, Mr. Colbert, your case is 22 CR 0031116B, and once you're charged with battery of family violence, which is with the offense date of May the 19th. Do you understand those constitutional rights that I just explained to you?
Yes, ma'am.
All right. Mr. Howard, I see that he is recommended. What is the history, please?
7 total. Last 2019 felony theft by taking. I think it was reduced to a misdemeanor. 2019 probation violation for burglary. It came off a 2009 case. 09 SC 86433.
Oh, and as an announcement, those who receive a surety or cash bond today will be reset to the SAP calendar on June the 2nd of 2022. Please continue, Mr. Howard. Thank you.
2019 suspended registration, driving without a valid license, and DUI. That's it.
All right, thank you. All right, whose case is this for the state?
It is mine, Your Honor.
All right, good afternoon, Ms. Segura. What is the state's recommendation?
Good afternoon. The case started on May the 19th, 2022 at the incident location of 2201 Old Madison View, South Walton. In this instance, officers responded to the incident location in reference to a report of domestic dispute. They made contact with the victim, Ms. Kiana Bynet. Kiana, spelled K-I-A-N-N-A, Bynet, B-Y-N-E-R, at the rear end of her residence. She said the defendant pushed her and choked her. When police were at the scene, they found the defendant hiding on a second floor bedroom. Once discovered, he said that he did not push her but brushed her. At that point, police also noticed swelling on the left side of her cheek of Ms. Barnett. The state is recommending a $5,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons, a stay away from the 2201 Old Madison View location, and no further contact with Kiana Bynet. Changes are based on these facts, as well as because we're concerned about the safety of Ms. Bynet as she does reside at the same residence, and also because we were not able to make contact with her this morning. We want to have that stay away. And also we want to point out that even though the defendant disputes that he pushed her, he did say he did make some type of physical contact by saying that he did make a brush with her. Thank you.
All right. Is Ms. Biner present on the Zoom conference? If Ms. Biner is present and would like to be heard, this is your opportunity to do so. You're not required to make a statement in this court today, but you are permitted to do so if you are present. All right. Who represents Mr. Colbert?
Your Honor, Owen Lynch, present.
All right, Mr. Lynch. You represent this defendant. What is your recommendation?
Your Honor, we would ask the court to consider a signature bond in this case. Mr. Trebias is 31 years old. He does have a good job that he's been working at for the last 6 months at Little Caesars Pizza. He does have 2 children, not with the alleged victim in this case, is my understanding, ages 6 and 8 years old. He is a resident of the address that was listed by the solicitor in this case. But in lieu of a signature bond, we would ask that the court set a very reasonable bond. I do not believe he has an extensive criminal record, although I understand you've heard what was mentioned. So we would ask the court to consider a signature bond in this case. From speaking to my client briefly, he does not believe that at this point he would be able to post a bond. So I'd ask the court to to take that in consideration as well.
All right. And if I do order that stay away, Mr. Lynch, does your client have somewhere else he could stay temporarily? I don't believe there's been adequate cooling off here.
Your Honor, I have not determined whether he has another location to go. I know that I believe that there would not be an issue staying away from the alleged victim in this case. Can't speak to what other address he could go to.
All right. Thank you, Mr. Lynch. I appreciate that. All right. At this time, the defendant is going to receive a $1,500 surety bond. He is to have no further contact with the victim, last name Biner. He is to stay away from the address on Old Madison View in South Walton. He is to have no weapons, drugs, or alcohol as a condition of this bond. All right. Is there anything further from either party? All right. Mr. Lynch, does that conclude your business with this court?
Not today, Your Honor. I believe I have two other positions on this calendar.
All right. And as a reminder, his reset date will be June 2nd of 2022, whereby this can be revisited.
Thank you.
All
Your Honor.
right. Who do we have next?
We have Arnold Simulator. Position number 1.
All right. Good afternoon, Ms. Arnold. Your case is 22 CR 003115D, and what you're charged with battery family violence with the offense date of May the 19th. You understand your constitutional rights?
Say it again.
Yes, ma'am.
Thank you. Who represents Ms. Arnold?
Your Honor, that's me.
All
Owen
right.
Lynch.
All right, Mr. Lynch. Mr. Howard?
This is her first arrest. She need a cosigner.
Okay. All right, Mrs. Segura.
This incident occurred on May the 19th, 2022 at the incident location of 1090 Brooks Glen Drive, Boswell. In this incident, officers responded to a domestic violence call at the incident location and talked to the victim, the father, Jason Arnold, both common spelling. He stated that the incident started when his wife, the defendant's mother, told her that her boyfriend had to leave the residence. The defendant became upset, went into the kitchen, and began to take things out of the refrigerator and throw them onto the ground. The defendant then became more upset and intended to lunge at her mom and her sister, Jennifer Arnold, common spelling for both again. Mr. Arnold attempted to restrain the defendant from getting to her mom and sister by bell hugging her from behind. By doing so, the defendant began to kick, scratch, and attempt to bite. And Jason Arnold had scratches on his arm when I came to visit him. As such, the state is recommending a $2,000 surety bond, 1-day anger awareness, non-alcohol, drugs, and weapons, a meeting of a social worker due to reasons I'll explain later. No further violent contact with Jason Arnold, and curfews because we noticed that she, due to her age, might be best to have curfews. We spoke to her father earlier today.
I'm sorry, due to her age, it might be best to have what?
A curfew with conditions.
Okay.
And we spoke to Mr. Arnold earlier today, and she said that both his wife and other daughter were having problems with the defendant acting out and throwing things inside the house. He also stated that the defendant has been diagnosed with anxiety disorder and is on medications. He stated that during the incident, the defendant was arguing and yelling with her mother, and then the defendant stepped in, and when she was committing her outburst. At that point, the defendant, the dad, ended up bell hugging her to restrain her, and the most he just confirmed what was in the warrant. Thank you.
All right. Thank you, Mrs. Segura. At this time, before I go to you, Mr. Lynch, I'm going to sound for the defendant's father, Mr. Arnold. Mr. Arnold, if you'd like to make a statement, this is your opportunity to do so. Do you wish to make a statement today?
Yes, Your Honor.
All right. Before you begin, I need you to raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right. Of primary concern for the court today is whether you wish for your daughter to be able to return home. I understand there were some sensitive concerns, maybe perhaps concerning some medical conditions. I like to refrain from mentioning those as best as you can as we discuss this. But what would you like to tell the court today, Mr. Arnold?
I guess what I would like to tell the court is I would like for her to return home. I don't feel like she's a danger to me. I think things got out of hand. She got very upset and things could have been handled better. But we've been actively working on getting her some help with that, and she's been actively working on it. And I think that the best way to be able to continue that would be for her to be able to come home and us to keep working on it and facilitate some of her appointments and what we need to do to help her out.
And you would be willing to serve as a co-signer, because I've been heard from pretrial services, if I decide to send her bond through there, that she would need a co-signer. Would you or your wife be willing to do so for her?
Ma'am.
Thank you, Ms. Arnold. Nothing further. Mr. Lynch?
Yes, Your Honor, I would just ask that the court consider a signature bond in this case as well. She is 17 years old with no criminal history, and allowing her to return to the incident location, I think, is appropriate, especially based on the testimony from Mr. Arnold. So I just ask that Your Honor consider that signature bond, or at least a very reasonable bond that she can make in this case.
All right, thank you. At this time, Ms. Arnold is going to receive a $4,000 signature bond through pretrial services. She's to have no further violent contact with the alleged victim, last name Arnold. She is to have no weapons, drugs, or alcohol. She shouldn't have alcohol anyway, as a condition of this bond. Is there anything further from either the state or defense?
None from the defense.
All right, best of luck to you, Ms. Arnold. Please listen to your parents.
You
All
want
right,
the-
who do we?
Hold on. You want the parent to bring a utility bill since they're at home?
I'll waive the utility bill requirement.
All right, just tell the dad to sit tight. I'll give him the directions on where to
Mr. Arnold, you'll receive some directions from pretrial regarding how to be able to process your daughter out. All right.
Valid ID as well, though.
All right, Mr. Arnold, did you hear those instructions? You'll need to bring a valid ID as well.
Okay, and I'll get further instructions on when we can
Yes.
pick her up.
Yeah, I'm about to put
Yes.
it in the chat now.
If
Okay.
you look in the chat feature of the Zoom conference, there'll be some information. All right, best of luck to you. Who do we have next?
Position number 14.
All right, good afternoon. Are you Charity Scriven?
Yes, ma'am.
All right, Ms. Scriven, your case is 22 CR 003128Y, in which you're charged with battery family violence with the offense date of May the 19th. Do you understand your constitutional right?
Yes, ma'am.
All right, thank you.
First
Mr.
arrest.
Howard,
First
first arrest. Thank you. We'll go straight to Ms. Sowry. Good to see you this afternoon, Ms. Sowry. What is the state's recommendation? Ms. Sowry, you're muted.
Sorry, good to see you as well, Your Honor. This is a cross-defendant case with position 15. I don't know if you want to hear them both together.
All right. The court is agreed. Let's take Ms. Scriven's case first, and if we're able to go to that one next, we'll do so. All right?
Yes, Your Honor.
All right.
Your Honor, this incident took place at 600 Phipps Boulevard in Atlanta. Officers responded regarding a dispute call, and officers met with the defendant, who stated that she and the cross defendant, whose name is Brett Shaner, that's SHANER, they went to get breakfast that morning and got into a verbal altercation when they returned to the apartment. The defendant stated that during this verbal altercation, the cross defendant slapped her and started filming her while she was naked and undressed. The defendant then stated that she attempted to knock the phone out of the cross defendant's hand when he held her down and punched her. When officers arrived, the defendant had an ice pack on her eye, but there were no visible injuries. When the officer spoke with the cross defendant, he stated that they did get into a verbal altercation, but it was the defendant who struck him first. And he started to record the defendant's actions. He sustained injuries, scratches on his neck, and the cross defendant also did admit to mushing the defendant to get her off of him. The state's recommendation is a $3,000 surety bond with conditions of no contact with the cross defendant, 1-day anger awareness course. And at this point, we're not sure who owns the property or whose name is on the lease, but if that could be sorted out, we would issue a stay away to whomever is not the owner. Nothing further.
All right, thank you. Ms. McLeod, this is your client?
Yes, Your
Actually,
Honor, Mr. Sherry is the
Charity.
cross defendant.
Yeah,
Okay.
so Miss Charity.
Oh, it's you, Ms. Kim. Okay, good.
Yes.
Okay. Good afternoon, Ms. Kim.
Good
Your
afternoon.
recommendation?
Yes, I would like to request for a signature on bond. She's recommended and she is 21 years old and the lease is in her name and also her mother's name. So that belongs to my client, the place. And Mr. Brett Schinner, actually, he can go to another place because he's actually from Los Angeles and he was there to pick up his stuff. So I don't think that he should be living there. Miss Charity she has been here in Georgia about quite a bit here. She went to high school and she went to Emory Hospital as patient care assistant. She's trying to get nursing license in a few months. And also she's taking classes at MIT for e-commerce and digital marketing from this coming semester. And we would like to request for signature on bond. She was not a first primary aggressor. Thank you.
All right, thank you. Ms. McLeod, very briefly, is the information that you have from your client that address belongs to Ms. Scrivener and he would be able to go to a different location?
Your Honor, her name is on the lease. My client actually works in California. He tells me that he usually comes to Atlanta perhaps once a month or so because the parties were in a relationship which seems to be ended now. So essentially he resides and works in Los Angeles, in California.
Okay, thank you. All right, at this time, the defendant is going to receive a $4,000 signature bond through pretrial services. She is to take the 1-day anger awareness course. She is to have no further contact with the cross defendant, last name Shaner. She is to have no weapons, drugs, or alcohol as a condition of this bond. All right, is there anything further from either
Nothing
party?
further from the state.
Nothing.
All right, best of luck to you, ma'am. Who do we have next? Can we take the cross defendant? Is that possible?
What was that bond amount?
Yes, we will take the number 15. Give us 1 second.
Thank you.
4,000.
I was
Bond amount
4,000.
is 4,000.
Both of y'all talking, what'd you say? Judge, what was the bond amount?
4,000 signature,
No contact or no violence?
no contact.
That's anger awareness?
Yes, must complete the course.
Yeah, I was on the phone with the father, so I had to give him some more.
That's no problem. All right, Mr. Shaner, your case is 22 CR 003129Y, and what you're charged with simple battery family violence with an offense date of May the 19th of 2022. Do you understand your constitutional rights?
Yes, ma'am. Yes, Your Honor.
All right, Mr. Howard, can I have his history?
Second arrest. He was arrested June 2021 in Henry County. Possession of a Schedule II controlled substance. Sale of marijuana. I think that's open. It just says bond over. That's all.
All right, thank you. Ms. Tyree, I believe the facts of the case will be the same as you just discussed. So I'll just take the state's bond recommendation.
Yes, Your Honor. The state's recommendation is a $3,000 surety bond. In this case, it would be a stay away from the incident location, no contact with the cross defendant, and a one-day anger awareness course. Nothing further.
All right, Ms. McLeod?
Yes, Your Honor. My client is 26 years old, and as I mentioned earlier, he is a videographer working in the state of California. He was in a relationship with a cross-defendant, Your Honor, and he would come to Atlanta, say, once a month or so they could see each other. So there is not going to be an issue with him staying away from her. I do believe, Your Honor, that based on his lack of a criminal history, he has not been convicted of anything yet, that he could have a signature bond, Your Honor. He has assured me that he doesn't have any problem coming back for any hearings that he may have in the future. He did have a flight scheduled for tonight to leave to go back to California to work.
All right. All right, in light of that open case and the other information before me, Mr. Shane is going to receive a $1,500 surety bond. He is to have no further contact with the cross defendant. He must stay away from the incident location, and he is to have no weapons, drugs, or alcohol as a condition of that bond. Are there any questions from either the state or defense?
Your Honor, did you impose the one-day anger awareness or?
No, he's receiving a surety bond.
Okay, thank you.
All right, is there anything further?
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position number 3. Come on, Finley. Come on up, Finley. I'll bring you. Sit back there, bro. Number 3.
All right, good afternoon, Mr. Finley. Your case is 22 CR 003117C, in which you're charged with criminal trespass with the offense date of May the 19th of 2022. I advise you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard.
It's Wyatt Finley. 33 total. Last arrest was last week. Criminal trespass. I'll put the other charge in the chat. It was on
Okay.
Marta. Judge Mincy gave him a $3,500 bond, told him to stay away from Marta.
$3,500 signature?
Through the jail, correct. It wasn't pre-trial.
All right.
You
All
want me to keep going? He was
No, I
arrested
think
in April for trespass on Marta as well.
Okay, I think I've got it. Thank you, Mrs. Segura.
The incident occurred on May the 19th, 2022 at Marta, located at 70 Hamilton E. Holmes Drive, South Northwest Atlanta. In this instance, officers observed the defendant near the Marta Breeze machines. Officers recognized him as he had 2 prior active Marta suspensions. One year suspension started on August the 15th, 2021, which will expire on September the 15th, 2022, and a second 1-year suspension, which was started on December the 3rd, 2021, and would end on January the 3rd, 2023. The state is recommending a $1,500 surety bond, no alcohol, drugs, and weapons, and a stay away from all Marta stations. As Petra has noted, the defendant has several criminal trespass guilty convictions relating to Marta, one from April the 1st, 2021, which is 22 CR 001956C, which was a condition to abide by Marta suspension, and another one from last week, May the 12th, 2022, which is 22 CR 002907C, which was the Arnold's the one that did a bond order that had to stay away from all Marta's locations. Thank you.
All right, thank you. Who represents Mr. Finley?
It's Mr. Attorney Mike McLean. He was here and
Mr. McLean, are you present? Oh, he's walking over. Yes, Mr. I'm presuming that you heard Mrs. Segura's recommendation and arguments. What is your response in the defense's position? We can't hear you, Mr. McLean. If you're speaking, you're still muted.
My apologies, Your Honor. Our Xerox machine nearest me was not working, so I had to go to another Xerox station to print out certain things. And I did not hear Mr. Segura's recommendation. On which case was it?
We're on position 3, Mr. Finley. I'd rather not have Mr. Segura go through the entire thing, but his recommendation is that your client receive a $1,500 surety bond, stay away from MARTA, and have no alcohol, drugs, or weapons.
Your Honor, the reason.
Are you aware of his history, or would you?
I am, Your Honor, and I understand.
Okay.
I understand the state's argument. The reason we would ask the court to consider a signature bond is mostly because of the level of the offense, and secondly, a certain misunderstanding. Mr. Finley described to me that although he had the bans or the suspensions rather for MARTA, they had also told him that he had 30 days to come get his phone. And so he and I had a discussion where he now understands that if you see a contradiction and they're saying you're suspended for MARTA, but you've got 30 days to come get your phone, the better way to handle it would have been to call and get a police escort to the place where he has to go get his phone. So it was a misunderstanding. I have not yet analyzed it down to the point of saying it's a mistake of fact instead of a mistake of law, but I tend to think it's a mistake of fact, which is a criminal defense.
I think I recall this case. All right. Thank you, Mr. McLean. At this time, Mr. Finley is going to receive a $500 surety bond. He is to stay away from MARTA in its entirety, and he is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you, Your Honor.
All right. Is there anything further? If not, we can move. Would it be possible for us to go to position 11 at the jail?
Yes. Position,
All right, thank
Mr.
you.
Langford.
Yes, can we go to that position, please? I see private counsel on the Zoom conference for Mr. Langford. Mr. Langford, I see you're approaching, so I'm going to begin. Your case number is 22 CR 0031224C, in which you're charged with 1 count of battery family violence with the offense date of April the 3rd of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard?
Sorry, Judge. Are you asking for Mr. Howard or?
Yes, I haven't gotten to you yet, sir. We're gonna
Okay.
hear first from pretrial to get the history.
Sure, not a problem, Judge.
This is 4th arrest. Last was 2015, suspended license, no law. 2012 forgery, 4th degree, that was dismissed. And 2011 suspended license, dismissed. He was recommended.
Okay, thank you. And whose case is this for the state, Mr. Cheney? Good to see you this afternoon. What is the state's recommendation?
Thank you, Your Honor. The state's recommendation is a $3,000 surety bond because it is a family violence case. No contact with victim. Stay away from the incident location. No weapons, drugs, alcohol. This actually occurred on April the 3rd of this year, Your Honor. The defendant and the victim, who have children together, basically got into an argument which turned physical. It was over some text messages which the defendant saw on the victim's phone. He then hit her 3 times in the face with a closed fist, causing a bloody mouth and a cracked and swollen lip. We would also recommend a anger assessment class if Your Honor does not give the surety bond. The victim, who I believe is on the line, according to defense counsel, states that they've been together for 8 years, have 2 children together. As I said, she wants him back home and she is on Zoom. Of course, we would oppose that, Your Honor. That is our case.
All right, what is the alleged victim's name, Mr. Cheney?
Tyara Willis. First name is Tiarra. Willis is common spelling.
All right, thank you. At this time, I'm sounding for Ms. Willis. Ms. Willis, if you are present on this Zoom conference and would like the opportunity to speak, this is your opportunity to do so. You would, however, have to turn on your camera and unmute the screen because we must be able to identify you.
Yes, ma'am, I'm here.
All right, Ms. Willis, do you wish to make a statement?
Yes, as
Before you begin to speak, please raise your right hand.
okay.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
What the court is most concerned with is whether you'd like to have contact with the victim. Please proceed.
Yes,
with the defendant. I apologize, with the defendant. Go ahead.
Oh, you're talking to me? Okay, I'm sorry. Yes, I would like to continue to have contact with him. I'm not in fear of safety. This is the first time something like this has happened, and he has expressed extreme remorse. We have 2 children together, an 8-year-old and a 2-year-old, and I don't want them to be away from their father. He has a good job. He's a good dad. And as I stated previously, this is the first time this has happened. I don't think it's going to happen again, and we definitely want him home.
All right, thank you. I'll go to your attorney now, sir. Mr. Arca, I believe. Mr.
Yes,
Arca?
Judge. Good afternoon. Thank you for the opportunity. Kyle is 29 years old, Judge. He lives here in Atlanta with his mom, his girlfriend, Tiara Willis, who you just spoke with. As you can see, they are taking this matter seriously, Judge. They have retained counsel. I've been in constant communication with Kyle, Tiara, and his mother as well. Judge, I believe they've been together about 8 years. They do have children together. This is the first time isolated incident. As you can imagine, they're a young couple, probably saw some text messages. Not going to get into that because this isn't the place or the time for it. However, going back to Kyle, Judge, he is an educated young man. He's doing very well for himself. He's also done some time at Gwinnett College. I forgot what he was majoring in there, but he did get an education from there as well. His employment status is he works for Greif Sweetwater Paper Mill in Austell. He's been there approximately 3 years, Judge. He's on the up and up through the management chain, and he's making some pretty good money from what I've heard through his mother. I believe the criminal history was a past of his, I think mainly juvenile, if I'm not mistaken, from what I've heard. However, in going through the all factors, Judge, obviously one, his whole family's here, which really consists of Tiara's 2 children and his mother. So he's not a flight risk. He's not at risk of committing any felonies pending trial. With regards to the victim in this case, you can see that she's appeared before you today. Out of her own free will, she has stated that she would like him to go ahead and return home. He's a good father, and it seems to be a one-time isolated misunderstanding. Judge, he's not a threat to the community at large. I just asked that he be released on a signature bond since they do have to save up money for their children and for further representation of my services. As you see, he's a young man. There's always that one point, right, Judge? So
I'm usually pretty good at the straight face. I'm usually pretty good at it, but that got me. Okay.
No, I understand,
All right.
Judge. But he is a good young man. He's been in communication with me since the moment he hired me, as well as Tiara. I asked that they get a signature bond just due to the fact that they're young and have a child to provide for. They're not dependent on anybody else but themselves. And with the no contact order, obviously, and if you request a anger management eval with any follow-up recommendations, he'll gladly go ahead and comply.
All right. At this time, Mr. Langford is going to receive a $4,500 signature bond through pretrial services. He is to take the 1-day anger awareness course. He is to have no further violent contact with the alleged victim, last name Willis. He is to have no alcohol, drugs, or weapons as a condition of this bond. All right.
All right, thank you, Judge.
Are there any other outstanding issues from either the state or defense here?
No, Judge.
All right.
Nothing from the
Best
state,
of luck to you, sir, and you can be excused, Mr. Arthur. Take care.
Thank you.
All right.
Next, we have you done. Position 5, Mr. Green.
All right. Good afternoon, Mr. Green. Your case is 22 CR 0031198, in which you're charged with public drunkenness with the offense date of May the 19th of 2022. Do you understand your constitutional rights?
I do.
All right, Mr. Howard.
21 total between South Carolina, Florida, and Georgia. Last arrest was 2018. Simple battery, criminal trespass, cruelty in the third, hindering 911 call, ag assault. Hold on. Everything was dismissed except for the disorderly conduct and the trespass. That was a conviction.
What was the year of the trespass?
All of that was one arrest.
Okay, all right.
2018.
Understood.
Yeah, it was
I
out of
got it.
Roswell.
All right, I understand. Thank you. Mrs. Segura?
This occurred on May the 19th, 2022 at Excel City, Excel spelled Xhale City, located at 1007 Alpharetta Street, Roswell. In this incident, officers responded to a call about someone making threats inside the incident location. Once inside it, the defendant was with store employees being unbalanced, and once he spoke, police smelled the odor of alcohol. We spoke to the defendant outside the store about what had taken place, in which he said that he was trying to return an item, but the store would not give him a refund. Then the defendant became aggravated when asked for ID, and he became more so when he tried to give it. The defendant became loud and boisterous, and a female known to the defendant, walked up to him and tried to calm him down. The defendant made a fighting gesture and was then arrested. At that point, he's told the police, quote, "I better not touch him again, and I will fuck you up." We actually sent a plea offer to the defense, but I'm not sure if they had time to actually communicate it to the defendant.
We did.
Right.
He is going to go pro se because the defense normally would like to develop the case more and have more rapport and more investigation. But I explained to him what the state's offer was, and I explained to them that he did have the right to go pro se if he wanted to do that today. And I believe that was
Right. My question would be, how would we get plea paperwork? Would someone at the jail be able to assist him? And Mr. Green, let me clarify, do you want to take a plea today?
Yes, ma'am.
You do. You spoke with Mr. McClain, and you feel that that's in your best interest?
Yes, I do.
Well, in courtroom 2, is there anyone who will be able to assist him with getting that plea paperwork over to us if
Yes.
he takes the plea? Okay,
Yes,
thank you. Thank you. Mrs. Segura, will you please put the recommendation for the sentence onto the record?
We did a time saved, so I believe he was in jail for 2 days now, and so it'll be 12 months itself 2 days, credit to time saved 2 days, balance suspended, and a stay away from the incident location.
All right, so you understand that, Mr. Green? If you choose to take this plea offer today, what would happen is your case would be closed out, but you could not return to the Excel City. You understand that?
Yes, ma'am. Yeah, I work for the liquor store.
I don't want you to say, I still don't want you to say too much, but you understand that part. You would be willing to do that, correct?
Yes, ma'am.
All right, I'm gonna ask you some questions to make sure that you are willfully and knowledgeably taking this plea, all right?
Yes, ma'am.
All right, please raise your right hand. I'm gonna swear you in just for the limited purposes of taking this plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury? All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Have you, you understand that you had a right to an attorney at this proceeding, but you're waiving that right?
Yes, ma'am.
And you understand that by taking this plea, you're giving up your right to go to court later and challenge this and to present any evidence you may have had and to have the state prove that burden against you beyond a reasonable doubt. You're willing to waive all of those rights.
Yes, ma'am.
And you understand there will be no later court date regarding this charge.
Yes, ma'am.
And all right, and you do understand what I said, that you cannot go back to that Excel City.
Yes, ma'am.
All right, as for the charge of public drunkenness, how do you plead? I accept your guilty plea. If you don't have other holds at the Fulton County Jail, you should be released shortly, all right? Best of luck to you, sir. All right.
Next,
All right, he'll need, I'm sorry. Yes, Ms. Lewis?
Excuse me, Judge. Mr. Sergio, the solicitor, you have to send that paperwork over to the jail, and then once it's completed, it has to go to Melissa Grace, who is the litigation manager for today. So you have to fill out your part and his part, and then send it over to us and for the judge and stuff to actually take his plea.
So just to clarify, you want me to send that care of Melissa Grace?
Yes.
Okay, we'll be sending that over shortly.
Okay. And Judge, you didn't take his plea all the way, did you? You're gonna come back and take his plea?
No, we took it.
Oh, okay. I thought you wanted to wait for the paperwork. Okay.
No, I mean, I'm assuming that because he is at the jail, he won't get out. There should be somebody to facilitate the paperwork process. All right?
Okay. Okay.
All right.
I just want to make
All
sure the paperwork gets in the proper hands. Okay.
All right.
Thank you.
Thank you. All right, who do we have next?
Position 6, Mr. Grimes.
All right, good afternoon, Mr. Grimes. Your case is 22 CR 003120F, in which Mr. Grimes is charged with 1 count of battery with the offense date of May the 19th. Do you understand your constitutional rights? You do not?
I mean, yes, yes.
You do? All right. Mr. Howard?
32 total. Last arrest was 2016 probation violation in DeKalb County. In 2007, they sentenced him to 20 years to serve 10 years probation in Gwinnett. Possession of a firearm during a commission. Possession of cocaine, carrying a concealed weapon, first offense. Possession of a firearm by a convicted felon or felony first offender. I think the last violent charge I saw was in the 1990s. Got a couple of parole violations from 2014, but yeah, I think it's been since the 90s.
Perfect. All
When he
right.
was
Thank you.
convicted for a violent charge.
I understand.
All right.
Okay. Thank you. Mrs. Secura?
This incident occurred on May the 19th, 2022 at the incident location at 931 North Avenue, Northwest Atlanta. Also responded to a dispute call at the incident location, and police met with a Miss Tiffany Thomas. Tiffany spelled Tiffany, Thomas, common spelling, who stated that while she was walking on North Avenue, the defendant went up to her and pushed her to the ground, causing her to have scratches on her knees and to experience leg pain. The defendant told the police several times before that, the defendant was told several times before by the police that to have a stairway have no further contact with Ms. Thomas, but still made communications. Ms. Thomas explained that in the warrant that the defendant used to call her to give her money and drugs. And police had multiple encounters in the past involving both parties fighting and engaging in verbal disputes. As such, the state is recommending a $5,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons, a stairway from 931 North Avenue, Northwest address, and no further contact with Tiffany Thomas. Details based on these facts, so as because of his history of violence in 2017 and the owners as noted by Pete trial, and because he does have a history of Ms. Thomas, and as noted in the warrant, police had more encounters with them physically fighting and having verbal disputes. Thank you.
All right, thank you. Who's Mr. Lynch? It's you. What is your recommendation?
I would ask that if a surety bond is set in this case, that it is less than the $5,000 that was recommended by the state. From speaking to Mr. Grimes, his sole income would be disability income, and I'm not sure what assistance he has. He's not able to work at this time. As far as the stay away, I'm not sure. He doesn't have an issue staying away from the address that was listed by the solicitor in this case. Now, his address is very close to that address, and the alleged victim in this case has no connection whatsoever. So just to make sure that there's no indication that he has to stay away from his own address, which would be 935 North Avenue. I'm not just making sure that that is not the intent of the state here. But we would ask the court to consider a signature bond. As was mentioned, it has been significant amount of time since there was any violent offenses for any convictions for anything violent. But at the very least, more along the lines of a $1,000 surety bond that he would be able to potentially make rather than the $5,000 bond suggested by the state here.
All right, thank you. I'm gonna sound for Tiffany Thomas. Is Ms. Thomas present on the Zoom conference? All right, hearing none. Mrs. Greer, I do want to clarify the incident location, that 931. Is it alleged that that is, what is the allegation from the state of that, what that address is? Because I do not want to prevent him from going back to his home if it is not alleged that Ms. Thomas lives there or resides there.
I believe the incident location was on the North Avenue Street itself, where she was walking. And by 391, I believe is her location.
So they're neighbors, essentially.
Yes.
Okay. All right. At this time, Mr. Grimes is going to receive a $3,500 surety bond. He is to have no further contact with the victim, last name Thomas. He is to stay away from 931, but he can return to his home at 935. He must say if he sees Ms. Thomas, or he shouldn't even walk that direction if he can avoid it, if at all possible. He is to have no weapons, drugs, or alcohol as a condition of this bond. All right. Is there anything further from either party?
Yes, I would like to say something, Judge.
I really don't want you to say something that may interfere with Mr. Lynch's ability to represent you, as the state is listening. Do you have a question about the bond itself? A very limited question?
Yeah, I had two questions.
I think the best thing for you to do is to speak with Mr. Lynch. I don't want you to inadvertently say something in open court that will end up being used against you, all right? All right, I believe that concludes his case. Mr. Lynch, if you wouldn't mind giving him a call at the jail at some point.
Absolutely.
All right.
Judge,
Thank you.
that concludes my business. May I be excused?
Yes, and if you would give Mr. Grimes a call, I would greatly appreciate it. Have a good weekend, Mr. Lynch. All right. Who do we have next?
Position 9, Mr. King.
All right. Good afternoon, Mr. King. Your case is 22 CR 003127Y, and what you're charged, one count of simple battery with an offense date of May the 19th. Do you understand your constitutional rights? All right, I hear you. I see you nodding, so thank you. Mr. Howard?
Jarrell King, third arrest. Last arrest was June 2021. Criminal damage to property, second degree, simple battery. That's open in Superior Court. 21 CP 200-290. 2019, 2 counts of felony terroristic threats. They were dismissed. That's it.
All right, thank you. Mr. Cheney?
Yes, Your Honor, the state recommends a $3,500 surety bond, no contact with the victim because of the condition of the victim at the time of the attack. Law enforcement responded to an altercation between the parties. Argument became physical when the defendant struck her in the head several times and pulled hair out of her head. The officer did see where all of this occurred, although he did not document visible injuries. We are still waiting to report to see if we can charge this as a battery. Also, stay away from the incident location, Your Honor, which is 436 Somerset Lane, Sandy Springs, Georgia. The victim is Amber Petty, Petty. She said she would be on Zoom if she made it back from the doctor's appointment where they were checking on the welfare of the unborn child. And basically, Your Honor, we would ask for no weapons, no alcohol, drugs, and no new violations. That is our case.
All right, thank you, Mr. Cheney. Whose case, is this Mr. McLean? Is this your client, Mr. McLean?
Yes, Your Honor.
All right, I'm gonna go to you shortly. I just wanted to clarify that. I'm first gonna sound for Amber Petty. Ms. Petty, if you are present on this Zoom conference, this is your opportunity to speak. As always, you are not required to do so. All
And Your
right.
Honor, if I may,
Yes.
further victim's notes is she did say she was afraid, she wanted no contact at all with this defendant, and it didn't look like she made it back for the Zoom call, but I wanted to let the court know of her intentions. Thank you, Your Honor.
All right, thank you. Mr. McLean?
Your Honor, we are in agreement that there will be no contact, and he understands the importance of that and is determined to have no contact. So he's in agreement with the state on that. Your Honor, I phoned his dad. I believe that the 436 so-and-so address shown on the booking sheet may be her place, so he'll stay away from that place. He would like to ask the court to consider a signature bond, or if that is not possible, no more than a $3,000 surety bond on this, Your Honor. Considering the main argument, we do recognize that there is trouble between these people that is built up, but our main argument would be the level of this offense, simple battery, family violence, is thank goodness not worse. So he will defend the thing in court later on, but ask that he be able to get out on bond with something like a signature or a $1,000, $2,000, or $3,000 surety.
All right. At this time, Mr. King is going to receive a $3,000 surety bond. He is to have no contact with Ms. Petty. He must stay away from that Somerset Lane address, and he is to have no alcohol, drugs, or weapons as a condition of his bond.
Yes, Your Honor.
All right. Best of luck to you, sir. I believe that will conclude that case, and we can go to the next position.
Position 13, Rogers.
All right, good afternoon, Mr. Rogers. Your case is 22 CR 0031266C, in which you're charged with battery family violence with the offense date of May the 19th. Do you understand your constitutional rights?
Yes, I do.
All right, Mr. Howard.
14 total between what's this? Michigan, Tennessee, and Georgia. Last arrest was in November 2021. Charges aggravated assault. That was out of Union City. 2016 possession of marijuana conviction. 2016 suspended license dismissed. 2012 probation violation. 09 probation violation. That's the Georgia history. I'm gonna go to Tennessee next.
I'm really just looking for something violent.
I got you. 2017 out of Tennessee for domestic assault. That was guilty. He had a 06 assault out of Michigan. I don't see a disposition for that. That's it as far as violence.
All right, thank you. Mrs. Segura, we'll go to you.
Actually, this case used to have a cross-defendant, which we did acknowledge this morning, but I noticed that in the chat, there was a reference to that cross-defendant for tomorrow. If I get some clarity on that.
Oh, Ms. Kim, it says that 14 and 15 are cross. Is that the comment?
I know that the second sentence, the cross-defendant of Rogers will be on tomorrow's calendar.
Okay.
If it helps, I have cleared that up with Ms. Kim. It was a confusion as to which cross defendant. There was another cross defendant, not this case, that will be heard tomorrow.
All right.
Okay. This incident occurred on May the 19th, 2022 at a travel lodge by Windham, located at 2471 Old National Parkway, College Park. In this instance, also responded to the incident location and reference to a verbal dispute. When they went to the front lobby, they saw a Miss Pauline Johnson. Pauline spelled P-A-U-L-I-N-E, Johnson, common spelling, run across the doors outside of the lobby to the ice machine. Police followed her because she seemed to be in distress and needed to be calmed down. When they came to confront her, they noted that she had visible scratch marks on her ribs and stomach area. She stated that the defendant, who was her boyfriend at the time, did it. They had an argument when they were in the hotel room, which became physical. On it, they talked about the defendant and the victim, and they were shown videos in which the defendant was speaking belligerently towards Ms. Johnson and throwing rocks at her, provoking her. The state is recommending a $5,000 cash bond, one-day anger awareness, alcohol, drugs, and weapons. A stay away from the home address which they both reside in, which is 2216 Tilhurst Street, Southwest, Atlanta, and no further contact with Pauline Johnson. Foundations are based on these facts, as well as because his history with Ms. Johnson. Both Ms. Johnson and the defendant lived together for over a year. And also in the warrant, it stated that he strangled her. So we're at this moment investigating this warrant to see if it needs to be upgraded to a felony. Alongside, is he has one history. In 2017, he has domestic assault conviction. We're not sure who that victim was in that case, but we do see a pattern in which he does have violent confrontations with people who consider family. And alongside, he has an open case, which was on August the 5th, 2021, 21 CP 204653 for aggravated assault family violence. And this case is actually with the same victim, Ms. Pauline Johnson. And we noticed that it's not been in a full year, and yet he made contact with her and actually battered her. So because it's strange violence, this extreme violence over the exact same person, and we have deep concerns for his safety, and that he will reoffend. As he does so, even though he had a felony, he's still committing that, not even 10 months. So thank you.
All right, thank you, Ms. Kim.
Yes, Your Honor.
Before I go to you, Ms. Kim, 1 second, I apologize. Ms. Johnson, if you're present on the Zoom conference, this is your opportunity to speak. If you would like to make a statement, although you are not required to do so. All right, Ms. Kim.
Yes, Your Honor. Mr. Rogers is 48 years old, and he has a sister here in Georgia. He's been here in Georgia from 2005, making him to stay here for more than 17 years. He has 3 children. They're all adults, and he has a mother here in Georgia. He has been working as an independent contractor, doing audio video for DirecTV for the last 25 years. His highest education is 11th grade in the high school. He does not have any mental health issues, and he would like to request for a signature on bond. And yet, considering the histories, we would like to request for the lowest possible surety bond, not the cash bond. He does not have anybody who can bail him out at this point, since Miss Johnson, Pauline, I don't think he can contact her. So, and his son is in Michigan, his daughter's in Florida. So he's got to do all by himself. So please give him a lowest possible bond. Thank you very much.
Your Honor, if I may quickly add, the defendant's bond and that aggravated assault was $25,000 surety with a stay away from Pauline Johnson and a stay away from the Fulton County for work, attorney visits, and court appearances. Alongside the allegations of that aggravated assault, it was that he knocked her unconscious in front of witnesses.
All right. At this time, Mr. Rogers is going to receive an $8,000 surety bond. He is to have no further contact with the victim, Pauline Johnson. He must stay away from the location. I could not quite understand the location. I might need you to spell that again, Mr. Segura. And he is to have no alcohol, drugs, or weapons as a condition of this bond.
The location, basically, this incident occurred in a hotel, but they both reside in a residence, and I want to have to stay away from both locations if possible.
All right, if you'll provide those stay away locations, I will grant that, both her location and the incident location. And go ahead.
The residence is a 2216 Telhurst, Telhurst Street, Southwest Atlanta. And the incident location is a travel lodge by Wyndham. Wyndham, WYNDHAM, and that is at 2471 Old National Parkway, College Park.
All right, thank you. Is there anything further from either the state or the defense as it pertains to this case?
Nothing further, Your Honor.
All right,
what was that bond amount? You said 8,000 or 8,000?
8,000.
Okay, 8. Okay.
8,000 surety bond. All right. Best of luck to you, sir. Who do we have next?
Position 16, Thomas.
All right. Good afternoon, Mr. Thomas. Your case is 22 CR 003134A, and what you're charged with 1 count of battery of family violence with the offense date of May the 19th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard, he's recommended, is this his first
Second
arrest?
arrest.
Second? Will you put the first arrest onto the record?
2009 of Frey out of Newton County. That's it.
All right, thank you. Ms. Dowry.
Yes, Your Honor. In this case, officers responded to 774. The street name is Avenida Street, Southwest in Atlanta, regarding a dispute. This is a cross-defendant case. Her name is Hoda, Hoda. Last name is Dirir. The cross-defendant advised that she bought a Nest system and the defendant changed the access code. And when the cross-defendant confronted him about it, he grabbed her by the hair, started punching and kicking her. And then he started to call for someone else that was in the home named Mr. Lewis, who is a witness to the incident. I'm sorry, he is a witness to part of the incident. The defendant then told officers that the cross-defendant pulled out a knife on him and threatened to stab him. And then that's when they started to tussle. The officers were able to recover a large butcher knife from the scene, and that witness, Mr. Lopez, he stated to officers that he came into the room where the incident took place and stated that he saw the defendant punching and kicking the cross-defendant. As a result, both parties were arrested. The cross-defendant, she was charged with ag assault with a deadly weapon. However, Your Honor, this cross-defendant did sustain bruises on her back, her face, and her abdomen. And those wounds would actually tend to show signs of a person that was being either beaten or beaten, and she then grabbed a knife to defend herself. So we would like the court to take that into consideration. The defendant, he did not sustain any injuries. The state's recommendation is a $4,000 surety bond with conditions of no contact with the cross-defendant, a stay away, and no drugs, alcohol, or weapons while on bond. Nothing further.
All right, Ms. McLeod.
Yes, Your Honor. My client is 31 years old. He is a native of Atlanta. He has 2 bachelor's degrees, one in accounting and one in marketing, and he is currently gainfully employed. The incident, the location where this incident is alleged to have taken place is his home. He does own that home, Your Honor, and he is the only person who is on the mortgage. The cross-defendant, he tells me, is someone who is a very, very good friend of his. They are not and never have been in a sexual relationship or anything. They're just very close friends, and they have lived together for some time. He said that they got into an argument, and the cross-defendant attacked him, and she did, in fact, hold a knife on him, and he was just defending himself, Your Honor. I would ask the court to consider giving him a signature bond. He has been charged with affray, a minor offense, some time ago. It wasn't said whether or not he was convicted of this offense, but the fact is he does not have any significant criminal record. He is gainfully employed. This was his home, and these are just allegations. And as I said earlier, he tells me that he was simply defending himself. He has expressed to me that he really feels bad about this incident because this was someone with whom he was very, very close. They just have been really good friends, and he's sorry that this incident happened. So given all of those facts, Your Honor, I would ask the court to consider giving my client a signature bond so he can get out of jail and get on with his life, get back to work.
And Your Honor, I'm sorry if I did not mention, we would like the court to take into consideration that the bruises that were on this cross-defendant's back and her stomach, they're not what you would commonly see if this defendant was just trying to disarm her. He did punch and kick her during the incident. Nothing further.
Now, my question, I'm concerned if this is his home and, you know, the other young lady is a cross-defendant of this case, My concern is about not allowing him to return to his home. So
It
that's
is
the
his
only thing.
home, Your Honor. He's the one liable for the mortgage. She
Right.
isn't.
All right, Ms. Lowry.
Yes, Your Honor. In Ms. Holder's case, I see that it was received by the DA's office. However, I do not see an indictment for the charges, so I'm not sure if they issued any type of stay away at this point.
All right. At this time, what I'm going to do, Mr. Thomas is going to receive a $3,000 surety bond. He is to have no further contact with the cross defendant in this case. He can return to that address at Anita Street so long as that is his home, so I won't issue the stay away. He can remove to the home based upon that's the information in this, but he is to have no contact with her. He is to have no weapons, drugs, or alcohol as a condition of this bond. All right, is there anything further from either state or defense?
Your Honor, I'm sorry, I didn't get the bond amount.
35, I'm sorry, 3,000. All right.
Is that a surety or SOB?
It's a surety bond.
Thank you, Your Honor.
All right, who do we have next? Best of luck to you, sir.
Your Honor, this concludes my business for the day. May I be excused?
Yes.
Thank you, Your Honor. Have a great weekend.
Yes.
Position 17, Mr. Tootin.
Okay, Mr. Tootin, your case is 22 CR 003135A, in which you're charged with 1 count of battery family violence with the offense date of May the 19th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard.
2020, theft of property out of Arkansas. It was dismissed. This is second arrest.
Okay, thank you. Ms. Sowery?
Yes, Your Honor. In this case, officers responded to 2399 Parkland Drive in Atlanta regarding a dispute. The defendant told officers that he went to the incident location to retrieve his belongings when he got into a verbal dispute with the cross defendant, whose name is Alandra, that's ALANDRA, last name Daniel, common spelling. He stated that the cross defendant began to strike him on the back with closed fists. The officers did not know any visible injuries. And when they spoke with the cross defendant, she stated that the defendant became he actually physically attacked her after she refused to speak with him when he came over to gather his belongings. And the cross defendant did have bruising on her back. Also, Your Honor, it is important to note that this cross defendant advised that she is currently 6 weeks pregnant, or was when this incident took place. The state's recommendation is a $4,000 surety bond with conditions of no contact with the cross defendant and a stay away from the incident location. Nothing further.
Does the cross defendant appear on this calendar or no?
No, Your Honor. She was booked into the jail after the 10:30, so she missed the cutoff.
And she'll be on tomorrow's calendar?
Yes.
All right. Ms. Kim?
Yes, Your Honor. We would like to recommend for unsecured judicial relief, signature on bond. This is his first simple battery case. Of course, this is second arrest, but first one was actually dismissed, and it has nothing to do with the violence. He's 27 years old, and he is willing to stay at uncle's place or a friend's place, so he does not object to stay away from 2399 Parkland. So, and he's been here for about 4 years, and he has one child, 7 years old, and he has been driving trucks for the last 6 years. He graduated from high school. He has 1 year of college doing construction management as a major, and he just needs to have a one-time visit with a law enforcement officer for his personal belongings, and no further contact is also okay with him as well. Thank you.
All right. All right. At this time, Mr. Tinton is going to receive a $4,000 signature bond through pretrial services. Is to have no further contact with the cross defendant, and he is to stay away from that address on Park Lane Drive. He is to have no weapons, drugs, or alcohol. He can return one time with a member of law enforcement to get his items.
Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Mr. King, position 10.
Before I go forward, I did not sound for that victim. Oh, she's a cross defendant, so that was great. All right. Mr. King, position 10.
Yeah, ma'am.
All right.
My mama here.
All right, Mr. King, your case number is 22 CR 003123C, in which you're charged with 1 count of criminal trespass and 1 count of committing certain prohibited acts while at a rail station, each with the offense date of yesterday. Do you understand your constitutional rights?
Yes.
All right, Mr. Howard.
His fifth arrest. Last was back in April on Marta for theft by taking. It's open in state court, 22 CR 002260C. October 2021, trespass. That was on Marta. September 2021, possession of marijuana.
All right, thank you, Mr.
And his
Cheney.
first cycle was a juvie arrest. My bad.
Okay.
All right.
Thank you, Your Honor.
Mr. Cheney?
On
Yeah.
May the 18th, 2022, the defendant entered into the Inman Park MARTA station, which is located at 70 H.E. Holmes Drive, Northwest Atlanta. He did so without paying the proper fare. That would satisfy the elements of both crimes. We'd ask for a $2,000 total bond, $1,000 surety on criminal trespass, $1,000 surety on the illegal acts. The reason for the surety, he continues to break the law in MARTA stations and has not been held accountable. We also ask to stay away from all MARTA, no weapons, drugs, alcohol, no new violations. Thank you, Your Honor.
All right, thank you. Whose case is this? This is Mr. McLean. Mr. McLean.
See if I can unmute here, Your Honor.
There you are.
There we go. Yes, Your Honor, his mom is on the Zoom call. We've had a good discussion about the whole thing in the past. He had been told to stay off MARTA. So I would ask the court to consider a lower bond than the 2,000 surety, even considering a signature bond, simply based on that one of the 2 counts is a fare evasion, which is at $2.50. So treating it more like the criminal trespass, which is the more serious of the 2, although they're both misdemeanors, we'd like to ask the court to consider a lower bond of only $1,000 surety or possibly a signature bond. We've discussed what the suspension means, what the ban means. The address, the state had the address wrong, but it was, we stipulated that was Fulton County. It wasn't H.E. Holmes. It was actually on 1055 DeKalb Avenue, which is the Inman Park station. So he would like to ask the court to consider a signature bond or a $1,000 surety total.
All right, thank you. At this time, Mr. King is going to receive $1,000 surety total, $500 on the criminal trespass, $500 on the second charge. He must stay away from MARTA in its entirety and have no weapons, drugs, or alcohol as a condition of this bond.
And you said it's.
I'm here. Do I get a signature bond?
No,
I do not.
you do not.
I can't hear. I can't hear, Judge. I'm about to stay in jail.
All right, you've received the bond. The best thing for you to do is to speak with Mr. McLean, all right?
Where's Mr. Mr. McClay, I gotta stay in jail?
I'll explain it to you.
Hello, Judge.
Right.
I'm unfortunate right now. All of it. Hello, Judge.
Yes, Ms. King, I hear you. But we've already decided your son's case. All right,
Ms.
as you're not a victim in this case and your audio and visual is breaking up significantly, my advice is please give Mr. McLean a call. Your son has received a bond, all right?
And I'll call you back as soon as court's over.
He has received a bond at this time. All right, who do we have next?
Thanks.
You're done. Position 7, Mr. Johnson.
Raymond Johnson, I believe, right?
Yes. All right, good afternoon, Mr. Johnson. Your case is 22 CR 003121E, in which you're charged with 1 count of battery family violence with the offense date of yesterday. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard.
All right, I got third arrest. 2012 arrest out of Puerto Rico for stalking. And a 2015 arrest out of Florida. It just says open container. That's it.
All right. Thank you, Mr. Cheney.
State would ask the court to consider a $4,000 split bond, $3,000 surety on battery, family violence, $1,000 signature on criminal trespass, no contact with the victim, stay away from the incident location, no weapons, alcohol, drugs, or new violations. The defendant and victim got into an argument after the defendant had been drinking all night. He took her cell phone, destroyed it, and destroyed some other household items. Then when she tried to control him and have him quit destroying property within the house, he struck her in the face with an open hand, causing swelling to her left cheek. The officer did observe the injuries, hence the battery family violence charge. We have no contact with the victim. We tried to reach out to her, but she did not return our call. Nothing further on this case, Your Honor.
All right, thank you. Mr. McLean, this is your case as well. Before I do that, what was the victim's name, Mr. Cheney?
Your Honor, the victim's name in this case is, I'm so sorry, Ms. Falk's going to kill me if I quit. I don't put the victim's name on the record. It's Rosem Vasquez. First name is R-O-S-E-A-M. Last name is V-A-S-Q-U-E-Z.
Okay, I'm sounding for Ms. Vasquez at this time. If she's present on the Zoom conference and would like to be heard. All right, hearing none, Mr. McLean.
Your Honor, we do see, and we discussed the fact that it had been upgraded from simple battery family violence to the battery family violence because of the allegation that the swelling was observed by the officer. So we do understand that. And I talked with him also about the criminal trespass. The reason the defense would like to ask the court to consider a signature bond is that the recommendation from pretrial is a judicial non-payment.
McLean.
He doesn't appear, he's not recommended.
No, but let me say this, McLean, the bond assessment you have is incorrect because the person that did it had it as this being his first arrest. They didn't have his criminal history.
Oh, they switched. Do we have available a copy of it?
I just gave the history. I ended up having to run the criminal history myself. It was incomplete.
Right, I did hear that. I did hear that. Now, the things I think you mentioned was something in Puerto Rico, and that was a stalking in Puerto Rico, and also a open container in what state?
Florida.
Florida.
I defer to the judge on this though.
Right. Considering that, Your Honor, we would like to ask for a signature bond, considering that it is then the third arrest. We understand the recommendation has changed, but we would look to ask the court to consider that. The 140 Pine Street address, Your Honor, is not, sometimes we look at Pine Street and think it's a shelter. This is not. He was living in a hotel. It's the Budgetel, so it is paid for, and it is a hotel room. He will be around and will stick around and watch his court notices. He has the ability to check with, I believe it was through email. We'll make sure that if his address changes, that he will update the clerk.
Mr. Chen, I just wanted to clarify that the state was requesting to stay away from the 140 Pine.
Your Honor, we did ask for stay away from there because it was simply the incident location.
All
But
right.
the major thing is the no contact at all provision with the victim.
He
All right.
agrees, he understands and agrees to the no contact at all.
All right. All right, at this time, Mr. Johnson is going to receive a $2,500 surety bond. He is to have no further contact with the victim, last name Vasquez. I won't impose any stay away as it does not seem to be, I'll impose a stay away from the incident location, but I don't believe the state provided me with an address for the victim, so we'll just go with the incident location. He is to have no weapons, drugs, or alcohol as a condition of this bond.
What's your breakdown, Judge?
Okay, it's 1,500. Actually, you know what? It's 2,500 on the battery family violence, and it's going to be $1,000 signature bond through the jail for the criminal trespass. I keep forgetting it's on the next page. So it'll be 3,500 split in total, 2,500 on the count one, and $1,000 SOB through the jail on count two. All right, who do we have next?
Position 18, Walton.
All right, good afternoon, Mr. Walton. Your case is 22 CR 003130E, in which you're charged with 2 counts of criminal trespass and damage to property. Do you understand your constitutional rights?
Yes.
All right, Mr. Howard.
This 9th arrest. Last arrest was 2020. Suspended license, theft by receiving. Before that was 2019, misdemeanor possession of marijuana. 2019, suspended license. 2019, possession of a controlled substance. 2018, DUI. Giving false name, possession of a pistol by person under 18 years of age. Possession of marijuana, those were convictions from 2018.
All right, I think that's good. Thank you. Ms. Sowery.
Yes, Your Honor, this incident took place at 3256 Piedmont Road in Atlanta. Officers responded to a criminal damage to property call. The defendant was seen shattering the window of 2 cars owned by 2 different people. The first victim's name is Daniel, last name Granados, and the second victim is Richard Smith. As we've heard from pretrial, this defendant does have a history that consists of guilty convictions, so he does present a risk of reoffending. The state's recommendation on each charge is a $2,000 surety with conditions of no contact with the victims and a stay away from the incident location. Nothing further.
All right, thank you, Ms. Kim.
I apologize for phone. I just didn't know how to mute it. Mr. Walton is actually 21 years old, Your Honor, and he has been here in Georgia all his life. He has one child who is 2 months old, and he has a brother who can help out. However, he has no job at this point. He has been focusing on getting his GED after he quit his high school around 10th grade. And next Monday, Your Honor, he's graduating from GED school. So he really is eager to go back out and attend his graduation, Your Honor. Even though there are open cases pending, those are not related to criminal trespass. So we would like to request for signature on bond so he can get out. He has nobody else to help out at this point. So please consider that his financial circumstances as 21 years old. So please consider signature on bond. Thank you.
All right, at this time, Mr. Walton is going to receive a $2,000 signature bond through the jail. He is to have no further contact with either victim.
Thank you, Your Honor.
All right. All right, who do we have next?
Judge, you said $1,000 signature bond, right?
No, it's 1,000 for each charge, so 2,000 signature through the jail.
Thank you.
All right, thank you.
Next, we have position 4, Fuqua.
All right, good afternoon, Mrs. Fuqua. Your case is 22 CR 0031118E, and what you're charged with 1 count of battery, family violence, and 1 count of cruelty to children in the 3rd degree, with the offense date of March the 5th of 2022. Do you understand your constitutional rights? All right, Mr. Howard.
He has over 30 arrests between Florida, where they most come out of Florida. But he don't have any violence. It's mostly drugs
Okay,
and suspended license.
I'm sure Mr. Segura will fill in the gaps. We'll go right to you, Mr. Segura.
Incident occurred on March the 5th, 2022 at the incident location of 727 Aaron Avenue, Southwest Atlanta. Officers responded to a domestic violence call at the incident location. On the scene, the police met with the victim, Ms. Tamika Fuqua, Tamika T-A-M-I-K-A, Fuqua F-U-Q-U-A. She stated that the defendant became upset because he thought that Ms. Fuqua's 16-year-old daughter, Kay Rowe, Rowe spelled R-O-W-E, was being disrespectful to him. The defendant went outside to the porch while Ms. Fuqua closed the door to talk with her daughter. Apparently, the door was locked, which made the defendant even angrier. He kicked in the door, damaged it and the door frame, and said, quote, "Bitch, why did you lock me out?" The defendant punched Ms. Fuqua with his fist 6 or 7 times in the face. She fell down, and the defendant started to kick her all over her body. Then the defendant went out of the house and drove away in Ms. Fuqua's vehicle. When police arrived, they noticed that Ms. Fuqua had a bloody nose, a cut to her right hand, her left foot was bleeding, and she had swelling around her eyes. And during all this that happened, the daughter, Ms. Kay Rowe, was a witness to all of this. The state is recommending a $6,000 surety bond, $5,000 for the family body violence, and $1,000 for the cruelty to children, 1-day anger awareness, no alcohol, drugs, and weapons, a stereo from the 727 Aaron Avenue Southwest address, and no further contact with both Tamika Fuqua and Kay Rowe. Recommendations are based on these facts, as well as because we actually spoke with Ms. Fuqua. She gave us more information. She stated that she and the defendant had been together for 6 years, had been married for 5, and they lived together in the same residence, but the residence is under Ms. Fuqua's name. She stated there has been previous verbal and physical abuse, but this is the first time that she called the police. They do not have children together, but her 16-year-old daughter lives with them. She also stated she called the police because she is tired of being hit and verbally abused by the defendant. In this instance, she verified that the warrant by saying the defendant punched her multiple times in the face, then kicked her while she was on the ground. She said that she probably should have gone to a doctor, but she hasn't. And she stated that she had a swollen face and bruising afterwards. She also stated that she's afraid of the defendant and does not want him to return home. Due to this extreme violence, especially based on Ms. Fuqua's words, has been going on for a long time, we have serious concerns about her safety. As such, there's a reasoning for a surety bond. Thank you.
All right, Mr. McLean.
Right, Your Honor, the arrest history does indicate this would be the first violent arrest, and we understand what the state is alleging. However, we would ask the court to consider a signature or as low a surety bond as possible, far less than $6,000, more in the neighborhood of 1 or 2. He does work at Builders First Source. That's the name of the place. Builders ', First Source. He is a forklift operator there. He agrees to the stay away and he agrees to the no contact. Those are appropriate.
All right, thank you. At this time, Mr. Fuqua is going to receive a $2,500 surety bond, $2,000 on count 1, $500 on count 2. He is to have no further contact with the victims and he must stay away from that address on Aaron Avenue. He is to have no weapons, drugs, or alcohol as a condition of this bond. Are there any further questions?
No, Your Honor.
All right. Who do we have next?
Position, oh, he has a question, Judge.
Your Honor.
I can, Mr. Fuqua, if you have a question.
I mean, I think I got
ask
to put a judge. I mean, I want to know,
Well,
like,
I
my name
prefer to
is-
speak for you, Mr. Fuqua. We have a tradition of having lawyers speak for the defendants, and I will answer any questions that you have about court and about the law.
All right, Mr. Fuqua, Mr. McLean will give you a call shortly. All right, thank you. Who do we have next?
Position 12, Mr. Nakoma. Nakoma, okay.
Mr. Nakoma, your case number is 22 CR 003125G, in which you're charged with DUI and improper or erratic lane change with the offense date of May the 18th. Do you understand your constitutional rights?
Yes, I do.
All right, Mr. Howard, interested most in previous DUIs, of course.
Don't have
Or
it.
out? None? Okay, how many cycles?
So you want the history?
Yes.
Third arrest. Last arrest was 2014. Alien inadmissibility. 2010, dangerous drugs. Possession of a controlled substance. That was a conviction. That was out of Michigan, I think. Yeah, that was
Okay,
out.
thank you. Thank you. All right, Mr. Cheney?
Your Honor, state's recommendation, $3,000 split bond, $2,500 surety on the DUI, $500 signature on the erratic lane change. This happened, traffic stop on the intersection of Holcomb Ridge Road and Steeplechase Road. The defendant was weaving inconsistent speeds and changing lanes. The officer detected slurred speech, odor of alcohol, red and watery eyes. Defendant did not consent to field sobriety. He was taken in. The intoxilizer had a reading, false reading for diabetes. However, they took him to the hospital, Northside Hospital, and drew blood. We are awaiting results. That's the DUI less safe charge. Also, we'd ask for no driving except as determined by the Department of Driver Services or his ALS hearing. No weapons, drugs, alcohol, no new violations. That is our case, Your Honor.
Thank you. Mr. McLean?
Your Honor, the defendant did ask me to ask the court to set a bond at signature or 1,500 or less for surety. The reason being, and after analyzing the case, he was unsteady on his feet, but he did have a foot wound. It's true that he didn't want to do any field sobriety tests. I'm not sure the officer would have disagreed with the field sobriety test actually being inappropriate, but he did refuse the field sobrieties because of the foot wound. He did agree to the intoxilizer. It wasn't working. They tried it twice. It gave an error for diabetes. They checked his blood out. He didn't have diabetes. He didn't have any low sugar, so it's the machine. So having agreed to the intoxilizer, they asked him if he would agree to a bond, to a blood test, and he said sure. And so they took a blood sample and everybody's waiting on the results. He is hopeful that it will come back far less than 0.08. As far as weaving goes, I did see in the police report the phrase, I observed, they talked about the low speeds, that there was not a consistent speed of the vehicle. But as far as weaving goes, the pertinent part of the paragraph is, I observed the vehicle once crossed over the left dotted white lane marker with its left rear tire. Of course, that left me scratching my head about, I haven't seen many reports that talk about only a rear tire crossing a lane without the front tire doing it too. And so I do emphasize the word once, which would obviate the idea of weaving. For those reasons, we'd like to ask for no more than a 1,500 surety bond. This is first DUI, and he's trying to get his blood test to show that he wasn't impaired.
All right. In light of the information before me, the defendant is going to receive a split bond. On the DUI, it'll be a $1,500 surety bond. On the erratic lane change, that'll be a $500 signature bond to the jail. So that should be a total of a $2,000 bond split, as I just explained. He is to have no weapons, drugs, or alcohol And he is not to drive unless he has a valid license that's issued by the Georgia DDS at this time.
Yes, Your Honor.
Is there anything further?
Nothing from the state, Your Honor.
All right, best of luck to you, sir. Who do we have next?
We're completed here in courtroom 2, Judge.
This is what you're doing. You're talking.
All right. Good. Have a great afternoon. Take care.
Thank you. You too.
All right, we still have South Annex, so we're ready to go there.
Yes, Your Honor. Good afternoon, everybody. We
Good
have over
afternoon.
here positions 8, 19, and 20. And
All
the
right.
ladies are ready to hear their rights.
All right, good afternoon. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Furthermore, this proceeding is being broadcast over the internet, live streamed and recorded, which means that any member of the public can log on and watch this particular proceeding. Who do we have first?
Position number 8, Miss Kennedy. Come on, Miss Kennedy.
All right, good afternoon, Ms. Kennedy. I just explained your rights. Do you understand them?
Yes.
As this is your first arrest in case 22 CR 003122A, and when you're charged with battery family violence, we'll go directly to Mr. Cheney.
Your Honor, we'd ask for a $3,000 surety bond, no contact with victim Tevin Jackson, Tevin, last name's common spelling. Stay away from incident location, no drugs or alcohol, weapons, no new violations of Georgia law. This occurred actually on May 5th of this year. Basically confined to the four corners of the warrant, which is all I have. Defendant victim currently living together, altercation ensued, became physical. The defendant pushed the victim into a glass fish tank, which broke, and the glass caused a 5-inch laceration on the victim's calf. We have not been able to get in contact with the victim. As far as living arrangements, we were hoping that the court could get that information from counsel. That is our case, Your Honor.
All right, I'm gonna sound for Mr. Jackson. Mr. Jackson, are you present on the Zoom conference? And do you wish to be heard at this time? All right, hearing none, we'll go. Is this your case as well, Mr. McLean?
It is, Your Honor. I would have to go into breakout to find out about the living arrangements more. I really would be commenting more upon not arguing the facts as to guilt or innocence so much as pointing out something about the injury.
Well, as Mr. Jackson is not on the Zoom conference, I'm inclined to order a stay away and a no contact anyway. So I guess the only thing that we will be addressing, and if you don't have any objection, Mr. McLean, I'll allow you to lead your client in some testimony as to that very limited issue, unless you absolutely feel that a breakout is necessary as something sensitive might be disclosed.
No, Your Honor, what the court is saying would be appropriate. Let's get to the heart of the matter about the 2977 5th Street Apartment B. Who's on the lease there?
Ms. Kennedy?
He's asking me a question.
Right. Whose lease is it for that address, 2977 5th Street Apartment B?
It's mine.
Is your address?
Yes, sir.
How long have y'all lived there?
4 months.
Okay, and that's your place. Now, when I say y'all, I don't mean to imply that I've asked you if he's actually been a regular resident there at all, because I don't know. Now,
the court wants to know, does the victim live there with her as well?
Yes.
Has he been there?
Yes, he lives there.
All right. All right. That's
Now,
all I need to know.
The element I was going to mention about not trying to argue in front of a jury right now, but the point is that the two people went into the fish tank and it broke. The happenstance of whose leg got lacerated on a piece of broken glass, it could have been either one of them, because the fish tank broke as they were in an argument. So we would ask the court to consider a signature bond for this. She has no record. It is unfortunate that there was a laceration. It could have easily been her laceration instead of him. And it is
All right,
unfortunate.
I'm inclined to agree. I'm inclined to agree with you, Mr. McLean. She's going to receive a $3,000 signature bond through pretrial services. She is to have no further contact with Mr. Jackson, and she must stay away from 2977 Fifth Street for now. With this issue can be revisited at a later date. She can return one time with a member of law enforcement to get any information.
Yes, Your
All
Honor.
right. All right. Is there anything further?
Nothing from the state, Your Honor.
All right. Best of luck to you, ma'am. Who do we have next?
Petition number 19, Ms. Ward.
Good afternoon, Ms. Ward. All right. Do you understand your constitutional rights?
Yes, I do.
All right. Your case number is 22 CR 003133J, in which you're charged with criminal trespass, family violence, criminal trust, and 2 counts of criminal trespass and 2 counts of simple assault, family violence, each with the offense date of January the 1st of 2022. All right, Ms. Sowery. Oh, I'm sorry. Let's go to Mr. Howard. I'm assuming it's first arrest, but we confirmed that it is.
It's not. 7 total. She had a history out of one arrest out of Tennessee, 2017 for theft. That was a conviction. As far as violence,
Any FTAs as well?
no, she don't have any violence either. Last arrest was
Okay.
on the 17th of this month for suspended license and driving without a valid license. That's it.
Okay. Ms. Sowery?
Yes, Your Honor, the state is recommending a $5,000 split bond. That's $1,000 surety on criminal trespass count 1, 1,000 SOB for criminal trespass counts 2 to 3, and then a $1,000 surety on the simple assault, family violence count 4, and then $1,000 SOB for count 5. Your Honor, this incident took place at 1254 DeForest Village in Atlanta. When officers arrived, they spoke with the victim, whose name is Janae Collier, and she stated that the incident had occurred 2 days prior to them coming out, but an officer had not taken a report, and she stated that she needed a report because she was applying for a TPO and wanted to press charges. The victim stated to police that she and the defendant got into a verbal dispute regarding the defendant speaking on the phone with someone else. The victim stated she was afraid of what the defendant would do, so she then took her daughter to one of the bedrooms. She locked the door. She put her daughter in the closet and then locked that door just to keep her daughter safe. While the victim was locking her daughter in a closet, the defendant kicked the main door in an attempt to get in. So that's when the victim came out and she closed the door behind her and went into another room, and the defendant followed her to that room, and the victim asked the defendant to leave. When this defendant picked up a TV, she threw it in the direction of Miss Collier and also her daughter, whose name is Aleea, that's Aleeya, last name Ward. She threw the TV in their direction, and the victim then gathered her daughter and went to a friend's apartment who lives in the same complex. So, Your Honor, when officers arrived, they did find 3 damaged televisions. The victim's clothes were bleached and there was a hole in the wall. The victim informed our victim advocate that she called police because she didn't know what the defendant was going to do, but she is not afraid of the defendant and that she wanted contact. However, Your Honor, in a cycle of abuse case, this is a clear case of the victim going back to the abuser. The victim initially told officers she needed a police report because she wanted a TPO, and also the victim locking her own daughter in a room in a closet. It sounds like there is a need or a reason to believe that there's a need for a no contact order. So the state is recommending that no contact with the victim Collier, no further violent contact with victim Ward, a stay away, and 1-day anger awareness.
All right, at this time, I've received information that Ms. Collier is attempting to join the Zoom conference. Ms. Collier, are you present on the Zoom conference? And if so, would you like to be heard?
This is victim advocate. She's still trying to reconnect. She was like out in the country area. So she was trying to get to a more remote area to connect.
Okay, we'll go to Ms. Kim as she attempts to connect.
Sure. Ms. Ward is 35 years old. First of all, they do not live together anymore. And I spoke with Ms. Collier earlier. She is not afraid of my client. Indeed, this happened on January 1st, 2022, almost half years ago. And not that long ago, even Ms. Ward did a hair for Ms. Collier, and they became good friends. Their terms are good. She does not want to press charge anymore. And Ms. Ward has one child who is 15 years old, and she is from Georgia. She has been here in Georgia for all her life. She has families here. She has a job as a hairstylist. She also has a GED from Job Corps. We would like to request for signature on bond since this is first violence case, Your Honor.
All right, thank you, Ms. Kim. I see that there's a Janae who's turned on are you Ms. Collier?
Yes, I'm just in a really, really bad reception. I was waiting and then my reception went out. But
before you
we've
begin
resolved all issues.
stop before you begin speaking. Will you please raise your right hand? Oh, and she's gone. Please raise your right hand.
Oh, I'm here.
Please raise your right hand. Do you swear and affirm that the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court?
We've resolved issues amongst family. She's been making efforts to rectify everything that's been going on. She's agreed to speak with someone in regards to counseling and everything. So everything on my end is good. I did not pursue to press charges. They told me if I wanted to press charges, I had to contact the district attorney. I did not do that because arrangements had been made. So I wasn't aware that this was still even an active case.
All right. All right, thank you. All right, at this time, Ms. Ward is going to receive a $5,000 signature bond through pretrial services. She is to have no further violent contact with the victim, last name Collier and last name Ward. She is to have no weapons, drugs, or alcohol as a condition of this bond, and she must complete the 1-day anger awareness course. Is there anything further?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Ms. Ward. Who do we have next?
Next, we have position 20, Ms. Whitaker.
All right, Ms. Whitaker, your case is 22 CR 003132C, and what's your charge of simple battery family violence with the offense date of May the 19th of 2022. Do you understand your constitutional rights? You
Yes.
do. All right, Mr. Howard.
So first, you need a cosign.
Okay. Ms. Sari?
Yes, Your Honor. We may need a breakout for this case. I'm a little concerned that something may come out when the victim gives her testimony.
All right, if we could be placed in a breakout, I'd appreciate it.
And the victim is Natasha.
Hello?
Ma'am, they gone into a breakout room to
Okay.
discuss the case. They'll let you know if they need you in the breakout room or not. Just put your phone on mute and we'll get right back with you.
Okay, thank you.
Miss Whitaker, Nataka Whitaker, yeah, Miss Whitaker. I'm speaking to you, ma'am. Ma'am, Miss Whitaker.
Yes.
Okay, I am about to let you in a breakout room. There's going to be a thing that's going to pop up on your screen. You may have to go to another screen because I think you're on the phone and you're going to have to accept it and it's going to let you into a room. Okay?
Okay.
We are back. And Ms. Kim, did you need to speak with your client at this time? Or are you sure that what we could discuss, that an alternative member would be available? Ms. Kim, I can't hear you. You're muted. You're still muted, Ms. Kim.
Your Honor, I didn't have a chance to talk to my client yet about other possibilities. So I guess, can I have a breakout with her only? Or can I call the
yes,
jail? I
yes.
can
So
call the jail really quick.
call the jail very quickly. That will,
Sure.
Mr. Howard, how old does a person have to be to serve as a co-signer for another person?
Yeah. Hello. Can I speak to Miss Whitaker?
Miss Kim, please mute. Miss Kim, please mute now. All right. Mr. Howard, how old do you have to be to serve as a co-signer?
I mean, if it's not a parent, like 25.
That's what I thought. Okay.
I sent you that in PDF form. Did you get it?
Thank you. I appreciate it. I haven't checked, but if you sent it, I'm sure that I have it.
If she gonna need a cosign, I'll have to send you another one. So.
I believe she will.
Your Honor, we believe that her brother's girlfriend is older than 25 years old. So may we have that person as a co-signer?
Mr. Howard, does it have to be any type of specific relationship required for someone to co-sign for someone who's a minor?
I mean, you just do an adult cosigner, but I know we believe now that she's 25, but she's not. So, because they will turn her away.
All right. Is she 25, Miss Kim? You're not sure?
That's what I heard from my.
Okay. Then Ms. Whitaker will receive a $4,000 signature bond through pretrial services. She's to complete the one-day anger awareness course. She's to have no further contact with the victim in this case and stay away from the victim's address. Ms. Kim, if you provide the name and information of the co-signer, I would greatly appreciate that.
Sure, Your Honor. Can we have a one-time law enforcement?
Yes, she can return one time with a member of law enforcement to get any items, preferably at a time and location where Ms. Whitaker may not necessarily have to be on site.
Yes. Your
All
Honor.
right.
Okay.
Your Honor, what was her bond amount?
$4,000 signature bond.
Through a pre-trial,
Yes.
with a co-signer?
I'm sorry. Say that again.
Is that with a co-signer?
Yes. Yes. I'm sorry. I got a message. Yes, with a co-signer.
Okay.
All right, Ms. Sauer, you're asking me to revisit position 17?
Your Honor, may we be excused?
Yes, you can be excused at South Annex. Have a great afternoon.
Thank you.
You're
Bye-bye.
You're asking me to reconsider position. Ms. Grace, what did I do on position 17? Or Ms. Kim, can someone tell me what I did? I cannot read what happened.
I'm looking at it now, Judge. Position 17 was a $4,000 pretrial bond.
All right, and you're asking me to reconsider that, Ms. Sari?
I'm not sure if we can reconsider it, being that he's no longer here, but I was asking if you considered the fact that the cross defendant was pregnant at the time of the incident when this did take place.
I did.
Okay. Thank you.
All right. Next time, please ask me questions closer to the time that it's happened, such that if an amendment is required, we could do it at that point.
Yes.
All right. All right. Thank you.
Excuse me, Your Honor.
Yes.
She wants to know if someone is gonna come and co-sign for her to get out.
I am going to talk to her mom to get the phone number to kind of make an arrangement, and I'll call the job. I'll call the jail. So.
All right, Ms. Grace, will you review the, will you review?
Kim, how long is this gonna take? Because we get ready to go. And I need to
Oh
put
my
this in
goodness.
paperwork, 'cause
Okay, well, that sounds like a pretrial issue. Ms. Grace, will you please review the calendar?
Yes, ma'am. Position number one, $4,000 pretrial bond. Position number two, $1,500 good bond surety. Position number three is a $500 surety bond. Position number four is a $2,500 surety bond. Position number 9, took a plea. We have the paperwork, Judge. I'll be sending that over as well. Position number 6 is a $3,500 good bond. Position number 7 is a $3,500 split bond, $2,500 good bond, and $1,000 SOB through the jail. Position number 8 is a $3,000 pretrial bond. Position number 9 is a $3,000 surety bond. Position number 10 is a $1,000 surety bond. Position number 11 is a $4,500 pretrial bond. Position number 12 is a $2,000 split bond, $500 SOB jail, $1,500 good bond. Position number 13 is an $8,000 surety bond. Position number 14 is a $4,000 pretrial bond. Position number 15 is a $1,500 surety bond. Position number 16 is a $3,000 surety bond. Position number 17 is a $4,000 pretrial bond. Position number 18 is a $2,000 sign-on bond through jail. Position number 19 is a $5,000 pretrial bond. Position number 20 is a $4,000 pretrial bond.
Are there any other comments, changes, corrections, or questions? Is Ms. Falk still on the line? All right, I'll try to send Ms. Falk an email. All right.
Hold on, Judge. Hold on. Listen,